The First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good afternoon. We have two cases on the docket this afternoon, and we will take them in the order in which they appear. First before us is Joe Scott, Broward County Supervisor of Elections et al. Versus Geraldine Thompson et al. Case number 20-2445. Counsel for the appellants, you may proceed when you're ready.
Thank you, Your Honors. Good afternoon, and may it please the court. I'd like to reserve 5 minutes of my time for rebuttal.
So noted.
My name is Nick Shanine, and I represent Bill Cowles, the Supervisor of Elections for Orange County, but I'm here today on behalf of all 8 of the named county supervisors in this matter, hailing from Broward, Miami-Dade, West Palm, Duval, Hillsborough, Pinellas, Lee, and Orange. And they are unified here today to request this court to review and reverse a lower court decision that barred them from utilizing the proper application of the home venue privilege. Also here with me today is Mr. Rick Figlio. He represents Laura Lee, Florida's Secretary of State. He has graciously allotted to me the time for the argument. However, he is present should the court have any questions that would be more appropriately answered on behalf of the Secretary of State. We thank you for that, and I thank Mr. Figlio for his courtesy. With that, Your Honors, this is a public records case, and it's a public records case where these 8 supervisors of election that I just referenced, spreading out across the state, but none of which are in Leon County, were all sued in Leon County on a public records matter. This is not a new subject for this court. This court has recently held in Hernando County School Board v. RIA, a matter that is very similar to this matter, that governmental entities may only be sued in their home venue unless and only unless either an exception to the home venue privilege applies or that privilege is waived by the governmental entity. Here, there's...
I have a question for you about
Sure.
The statute that the appellees have cited as the basis for their venue. I understand the home venue privilege. I understand where it comes from, but I also see a statute about venue when you have multiple defendants. Why is it that a court should apply a common law principle regarding venue when we have a statute which appears to be right on point?
First, Your Honor, I need to clarify if we're talking about the venue statute 47.021.
I am.
Okay, great. Then in that case, Your Honor, the answer is clear because there are numerous stare decisis binding decisions of not just this court, but the Florida Supreme Court mandating that this home venue privilege is over and on top of 47.021. This court in RIA had the identical circumstances before it with multiple county school boards, none of which were in Leon County, being sued on constitutional deprivation to 4th graders trying to escalate in school without taking tests. And this court said, you can sue those school boards, but you have to do it in their home venues. But even before RIA,
does it matter that 47.121 wasn't mentioned in RIA or in the Sun Sentinel case or in many of the cases about home venue privilege that I've found?
It is true that it wasn't mentioned specifically in RIA. However, it is obviously because the school boards were the appellants. Had that been an issue, it would have certainly been raised as a tipsy coachman defense. It could have been raised directly by the court. But even if we accept it, somehow every party in RIA missed it and all 3 judges didn't see it. This court has said just 2 years prior to RIA in Hunter v. Shaw that Florida law does not recognize a co-defendant's exception. That just because you're a co-defendant, which is what 47.021 is all about, does not mean that the home venue privilege applies. Home venue privilege is the specific, 47.021 is the general, and the specific trumps general in all matters of construction. But
Mr. Shanine, let me follow up on that.
Sure.
The Secretary pointed out the Florida Supreme Court's decision in Williams, which of course dealt with the predecessor statute, but substantially similar. But even before that, I mean, can we look to the general principles of Thornburg that state, if a statute's going to abrogate common law, it must unequivocally do so. And this is probably a softball question to a certain extent, but it doesn't appear to me that the general venue statute unequivocally abrogates the common law home venue privilege.
Your Honor, you're not supposed to say the softball part out loud, but I accept the softball and will kindly return it as best as I can because Your Honor's absolutely right. Williams, which was the first case where the Florida Supreme Court specifically recognized the existence of a home venue statute. It talked about section 46.02, but the verbiage of that section and the verbiage of current statute 47.021 are identical. It's any defendant in any county, lets you sue. And they said specifically in Williams, we are not impressed by that argument, that we are not going to allow that statute to abrogate what was even then understood to be a common law principle. It's simply that common law principle hadn't been enunciated as the home venue privilege until Williams v. Lake City. And as Your Honor pointed out, even aside from the fact that the Florida Supreme Court in 1953 has said 47.021 doesn't apply, and no court since then has ruled differently, the principles that in Thornburg absolutely apply, where if there's going to be an abrogation of a common law principle, which the home venue privilege is, and Williams in that decision goes through the lineage of from whence that decision comes, distilled by the common law.
Well, if not the general venue statute, let's turn your discussion to section 97.0115, which preempts, as you know, to the state all matters set forth in chapters 97 through 105. And one of those chapters does require the retention of ballots, forms, and other election materials. And then, of course, the secretary has to maintain uniformity in the interpretation of implementation of the election law, So, I mean, is there an argument that could be made that it is waived by 97.0115 under those circumstances?
The argument, Your Honor, has been made by Mr. Cuny and the plaintiffs in this matter. That is not the argument that the lower court seized upon. The lower court solely ruled, I read 47.021, that says you can sue anybody anywhere, and that's what you're doing, as long as there's co-defendants. But Mr. Cuny has made that argument that the law is preempted because of the existence of that statute. The supervisors absolutely concur with the general concept that, of course, election law is preempted, just like firearms law is preempted, just like educational law is preempted. There are a number of bases by which preemption exists, but just because there is a general preemption does not change the fact that there is no specific, explicit designation by the legislature that we intend venue to be in Leon County. We intend venue to be where the state is. They can say that. They do say that in other contexts. That Mr. Cuny's argument later includes the fact that there's a statute within 102 which talks about in a multi-district election that challenge would be heard in Leon County. They specify in that statute, Leon County. If that were the statute we were traveling under, that's a waiver. That's a statutory waiver, and we would be in Leon County. This statute that says generically, all you supervisors maintain your public records, that does not, it doesn't mention venue. It doesn't mention anything about why we would be forced to have Miami-Dade supervisor of elections trying the case of whether Miami-Dade records that never leave the confines of the county of Miami-Dade would be tried in Leon County. That's not what that statute says. And there is no preemption exemption. That there are four and only, yes, Your Honor.
So I thought preemption simply meant that a subordinate governmental entity can't make laws that conflict with the superior governmental entity which announces preemption.
And Your Honor, that's exactly right. That preemption is being here writ too large. There's a reason why there is no preemption exemption. That yes, no supervisor can create laws that's for the legislature to do, and they preempted. Actually, not only no supervisor, but no county or other municipality can create the laws, only the legislature. But just because, and that's a that preemption is certainly there, that does not change where venue is appropriate. There are 4 exceptions and only 4 exceptions. Those are the sword wielder, the good cause, the statutory waiver, and joint tortfeasor. None of those 4 apply. The lower court didn't find any of those 4 to apply. The lower court only went with 47.021 because 47.021 does not apply by this court's decisions in Levy versus Bowden, Hunter v. Shaw, and the court's most recent decision in Rhea, and of course the Supreme Court decision in Williams. And because preemption does not create an exemption, nor does it equate to what the plaintiffs have argued, the supervisors of election respectfully request this court to reverse and remand such that this case would be sued by the plaintiffs against any supervisor they wish within that county that supervisor resides in, pursuant to the home venue privilege. Thank you, Your Honors. I reserve the rest of my time for rebuttal.
Thank you, Mr. Shanine. Mr. Cuny.
Good afternoon, Your Honors. Crystallized before this court is the question, was the trial judge correct in ordering in this election case, this case to be tried in Leon County? It bears no overstatement to recognize, as the trial judge did in argument, that this is a matter that needs to have a uniform final decision. And there are elections, statewide elections, that are impacted by the outcome of this case. Notably, as we pointed out in the pleadings, the 2022 general statewide elections. How is it that the trial judge, in applying the home venue privilege, in looking at the statutory scheme and finding in the exercise of his discretion, did the judge comply with the Rhea case, with the Brown versus Nagelhout case, which is the controlling definitive case here, the Grice case, and the other decisions that make clear, as Your Honors have expressed, the home venue privilege is not absolute, but is to be applied where its purpose is effected. A purpose.
I'm sorry, does it make any difference that the trial judge said none of this, didn't say anything at all about the home venue privilege, didn't analyze it, didn't actually say it doesn't apply here, in spite of the fact that that was exactly what the supervisors argued against?
Your Honor, I think it's clear from the 2-page order that the judge, acknowledging, having read the pleadings, home venue privilege starts nearly on page 1 of the pleadings and goes through the end. Having listened to argument, and this was a contentious argument, and having stated in the order, and I quote, the supervisor defendants also make essentially a forum non-convenience argument, although not characterized as such, and then proceeds to demonstrate the exercise of limited fact-based judicial discretion, finding why this case is appropriately joined for all the parties in an election law case that derives from the very ballots, the very counting of ballots for local, statewide, and national elections. So,
what provision of the election code was alleged to have been violated here?
there are a number of provisions, Your Honor, and although that is a merits-based determination not appropriate for review by this court on a venue review, we've cited the federal statute on election retention as applicable to the state. We've also cited to the public records requirements of ballot materials. We have contended in conjunction, and we point out in the briefs and in the complaint, that Florida has a very specific election law records retention provision, bound by Florida law, GS3, item 113, and we've cited this in the underlying complaint, we've referenced this in the briefs, makes clear that ballot material, including digital ballot images, are required to be preserved. They are included in the election retention provisions of the general statute. All those matters, Your Honor, have been itemized in the complaint, and they make clear that the underlying lawsuit is an election lawsuit that includes as a component of the election requirement for ascertainment and tabulation of the ballots, the requirement that, of course, election materials are public records, must be preserved, can't be destroyed, and the complaint without objection, but it's just at the motion to dismiss stage, Your Honors, makes clear that these digital ballot images are automatically created by operation of the machinery of the election process.
Well, let's focus on, so the home venue privilege is actually absolute with the exceptions carved out, judicially crafted by the Florida Supreme Court. So, and I know this was discussed in the brief, but let's walk through which exceptions you contend apply in this case.
Yes, Your Honor. And I do want to point out to the court that this court in the Bowden case has made clear, this court in the Bowden case cited by the parties has made clear that courts, quote, courts have discretion to dispense, end quote, with the home venue privilege when, quote, guided by considerations of justice, fairness, and convenience under the circumstances of the case, end quote. That, Your Honor, has always been the law in Florida and is the guidepost for the home venue privilege. But directly focusing on Your Honor's question, Chief Judge, we start with the Brown versus Nagelhout case that makes clear that the legislative prerogative in setting a place of venue is entitled to a place of prominence. That controls unless there is a reason it does not control. Home venue privilege, and noting, Your Honors, Brown versus Nagelhout dealt with a different common law exception known as the multiple residence rule, a different common law exception of similar origin. And it found that the venue statute took precedence over application of that common law exception. Here, we have using the statutory waiver argument as the principal reason underlying the rationale of the home venue privilege as being inapplicable in this case. And I note, Your Honor, not a single case cited by the SOEs, not a single litigation utilized by the SOEs involves any election case. There is not a single determination where SOEs have argued in an election case of statewide application that the lawsuit must be brought in 8 counties, 10 counties, 27 counties, and have disparate results. In fact, that plainly would not be an argument the SOEs would ordinarily make, because uniformity of the election laws is the prerequisite for Florida law.
Right. So I'm sorry, I want to go back to and focus on the exceptions. And certainly the Supreme Court in the Sun Sentinel case said that trial courts are bound to follow the home venue privilege absent one of the 3 recognized exceptions, and the court went on to create a 4th exception. So if you could turn back to which exceptions in particular do you believe apply here?
Yes, recognizing
the recognized exceptions.
Recognizing the Florida Supreme Court in Sun Sentinel made clear that the venue was never intended to be absolute as a privilege. The statutory waiver is the most applicable recognized exception, and it exists for two reasons. First, the language of the venue statute is plainly applicable here. Second, the other statutes that inform determinations of election laws make clear that one single place where the Secretary of State is located is the proper place for this litigation. And it is true that, as the SOE says, the legislature has never passed a law that says, oh, in election cases, this is an exception to the home rule privilege. And that is quite apparent because there is no election law case. No court has ever said the home rule privilege in an election law case takes precedent over the litigation of this matter in Leon County, where the Secretary of State is headquartered. And this is important because in the Sarasota Alliance case, where a court said the uniformity of the counting and recounting statutes do not apply locally. So this was a case that arose because a court said, we're not going to apply the preemptive prescription of Florida election law. Instead, it's going to be based on the varied application. The legislature immediately passed a law that said, we're correcting the statute to make it clear Florida election law is preeminent. It is preemptive. That is a plain and clear application of the fact that the legislature, when it is confronted with a case, a determination, an application that attempts to subvert the uniformity of Florida election laws, the legislature will respond. There has never been an effort, never, to confront or conflict with the uniformity of the Florida election laws. So Your Honor asked the question, why is it that the statutory waiver applies here, even recognizing that RIA went out of its way? This court made clear it did not consider or apply 47.021. And we've cited in the briefs the very specific language where the court made clear, the RIA court made clear, quote, it is undisputed, end quote, that exceptions 1, statutory waiver, 2 and 4 don't apply. And the court then crafted its own, the lower court, own exception that RIA found was inapplicable in a case that is completely different from this case. This is a statewide uniformity of election law case. RIA was local control of school boards and individual schools and students, completely different. But nothing in RIA is on its face or in its execution finds that the statutory waiver applied or did not apply. It was undisputed when the parties litigated that issue. Here, the statutory waiver involving a defendant, the Secretary of State, is proper venue and when allied, when read in consonance with the statutory provisions of the Florida Election Code, and we've cited them in the brief, they are not denominated venue statutes. They are denominated election law statutes.
Counsel, can I ask you, the Secretary of State made argument in the brief. Actually, they moved to dismiss themselves from the case arguing that they're not a proper party. Of course, that's not before us because, as the Secretary of State noted, that's not a reviewable issue at this time, at least not by appeal. So we have a case where the Secretary of State is a party and there's nothing that we can do about it. But what if the Secretary of State were not a party in this case? How would that change any of your calculus?
Two responses, Your Honor. And first, let me just note that this court in Volusia County versus DeSantis made clear that the Secretary of State is obligated to ensure the uniformity of election laws statewide. So we disagree with that position of the Secretary of State, but I recognize your hypothetical. If this case were brought merely against one SOE, the question is, can you bring this case in Miami-Dade County? That issue is not before this court. Frankly, it's unlikely that issue could ever be before this court or any court because of the requirement for uniform application of the laws. Could there be 5 lawsuits in 5 DCAs involving the identical issue with potentially disparate results on the single question? Are ballot images required to be preserved? Theoretically, there could be, but practically, there could never be because of the Florida legislative proscription that election laws must be uniformly applied and interpreted. So we do not see there any likelihood in Your Honor's hypothetical that there could be or would be individual cases, or that the
Thank you, counsel. Your time has now expired unless the panel has any additional questions. Seeing none, I will thank you for your arguments. I'll turn it back to Mr. Shanine.
Thank you, Your Honor.
Madam Clerk, if you'd please add the commensurate amount of time to Mr. Shanine's argument.
Thank you, Your Honor. In rebuttal, first, we have to turn to this Bowden case that he was just discussing, because the Bowden case couldn't have made it more explicit. This is First District back in 1992. Quote, the venue provisions of Chapter 47 Florida statutes do not abrogate this common law privilege, the home venue privilege. That's the direct quote from the very case that he's citing as an argument for why we should now expand or make elastic this home venue privilege. And I must turn to another point when he repeats that it is not absolute. It's not absolute. And Judge Ray, you corrected him, frankly, because that needs correction. It is and must be an absolute. There are the 4 exceptions. And those 4 exceptions, if they apply, are why you might be able to sue a governmental entity outside of their home venue. But as this court said in Jacksonville, JEA versus Clay County, and as the second DCA had said in Addison versus Tampa, unless a recognized exception applies, the home value privilege is absolute. And there's a reason for that, Your Honor. The supervisors of election have never, as Mr. Cuny points out, been sued outside of their counties individually to make this an issue that's ever come up to an appellate court, but certainly school boards have. And that's exactly what happened in RIA and why that case was before this court then, and why this court in RIA said the exact same thing. That was a case that he tries to distinguish it, but it's indistinguishable. It's a statewide case involving statewide application of legislatively set mandates that the Commissioner of Education was supposed to have control over. And despite that, this court had no issue in saying explicitly, no, you cannot sue these 8 school boards in Leon County. You must bring a suit against those school boards in their home venues. And this I've got to also return to is this construct that somehow it's impossible to sue one supervisor of election in their home county and get a ruling that would be of utility to them or the supervisors. And we frankly disagree as a matter of straight jurisprudence that of course they could sue. This is a public records case involving whether or not these ballot images that are maintained for 1/5 of a second at most while the ballots are being processed. And these large counties that he sued simply cannot maintain them without massive administrative difficulties, bogging down election results, increasing expense dramatically. There's a reason why these 8 counties do not do it. And there are plenty of other counties that don't do it either, but they weren't sued for reasons that we don't know. But they didn't need to sue all 8 counties, and they certainly didn't need to sue these 8 counties in a county other than their home venue and pick one that was none of their venue in Leon County. Instead, a single suit against, say, Miami-Dade in Miami-Dade would be a matter that could be heard there. Other supervisors would certainly, weigh in an amicus brief should that matter go up on an appeal. And when it did, that appellate court decision, then of the 3rd District Court, would be binding on everybody across the state uniformly. Prado v. State makes it clear that vertical stare decisis and horizontal stare decisis would both apply, so that every supervisor in the land would know what the rules are if a single county got sued in a single venue and the home venue privilege was properly applied, and we'd have an answer. We wouldn't have a multiplicity of results, and the statutes would be properly applied, and the home venue privilege, which is an absolute, would be properly maintained. For all of these reasons, Your Honor, the supervisors of election of each of the 8 counties, and Mr. Figlio is here on behalf of the Secretary of State, we respectfully request this court to reverse and remand so that the home venue privilege can be properly maintained, and we can proceed in whichever venue the plaintiffs decide to continue to, so long as that venue is in fact a home venue for the appropriate supervisor of election. Thank you, Your Honors.
Thank you, Mr. Sheney, and thank you, Mr. Cuny, for your arguments today. Oral argument on this case is now concluded. We'll go into recess. Have a good afternoon.
Thank you, Your Honors.